And this is Advocate Pawan here. Today we'll be dealing with one of the most important kind of questions which is required for your exam perspective. Detailed and elaborative manner. We'll be covering up everything now. So I want all of you to sit carefully, patiently listen, and then learn for the exam. Wishing you all the best. Now let's get started. Important questions, very important recent kind of judgments is what we want to deal now today. Let me give you the situation, then let's go with the question. Pawan sues Kamal for rupees 1 lakh, but neither attends court. The case is dismissed. Later, Pawan refiles it. Kamal argues res judicata. The court says no. The first case wasn't decided on merits. Pawan can refile it. Very simple. Pawan is filing a case against Kamal for how much? Rupees 1 lakh. But then Pawan will not attend it because I'm a busy man. But what will happen? Can Kamal file a case against, can I go refile the case once again? Yes. Why? Because it is my right for the same. Alright, this was decided in which case? Amruddin Ansari versus the Afzal Ali case. Okay. Mr. X filed a suit for recovery against Mr. Y due to a non-appearance. It was dismissed under Order 9 Rule 2 of the CPC. His restoration application under Order 9 Rule 4 was also dismissed. He then filed a fresh suit for the same recovery. Mr. Y claims it is barred by res judicata. Res judicata means what? Once a case cannot be happening again, right? Decide. The fresh suit maintainable since dismissible under 9. Order 9 Rule 2 is not a decree. I hope that's clear for you. Second question. Okay. Second question is what? Second question is about in the example. Pawan receives a gift deed from his uncle. So I am receiving what? I am receiving a gift deed from my uncle. Kamal later buys the same land from the uncle. Pawan does not need to cancel Kamal's deed. If his gift deed is valid, Kamal's sale deed automatically fails. Very simple. Okay. I'm receiving a gift deed from my uncle. Kamal later buys the same land from the uncle. Pawan does not need to cancel Kamal's deed. But if the gift deed is valid, then by default, Kamal deed is basically becomes failed. This was decided in which case? Hussein Ahmad Chaudhry versus the Habidi Rahman case. So in this, X claims ownership through a gift deed, while Y claims via a sale deed through from Z. X used for declaration but doesn't seek cancellation of Y sale deed. The trial court declares X title deed. The High Court receives the reverses it, holding X must seek cancellation. Decide. The High Court is wrong. X need only to seek declaration. He isn't party to the Y sale deed. Very simple as it. Next, third question. Kamal's father sells property in 2010. Kamal sues in 2015 to cancel it. Court says too late. Kamal 3 years expired in 2010. Possession does not extend time. So remember, a limitation period is what? Is always for 3 years. This is very important. I explain this again and again. C sues in 2015 to cancel a 2010 sale deed and recover possession. Court dismisses it as it is time barred. C argues 12-year limitation for possession applies. So very simple. Suit time barred. Primary relief is basically for 3 years limit. Fourth question. I hope this is very clear for you. Limitation period is always for 3 years. Pawan suit is dismissed as time barred even though no issue was framed. Kamal says no issue, no dismissal. Court replies, limitation is mandatory. Issue or not, your case is late. Okay? Remember carefully, the limitation period is mostly for how much years? It's only for the 3 years. The plaintiff A suit filed in 2015 is dismissed in 2018 as time barred. No issue on limitation was framed, but both parties argued it. The trial court right. The court can decide limitation even without framing the issues. Okay? So this is very simple. That is decide in which case? Nagraj versus the Rajmani case. Fifth question. Okay. Kamal admits in court that he is staying in Pawan's property as tenant. Pawan seeks eviction immediately. Court says admission enough, no need for trial. Very simple. Okay. So in an eviction suit, the defendant's written statement admits key facts. The plaintiff seeks judgment based on admission. Judgment on admission can be passed by at any stage, even without application, based on oral or written admission. Very simple. Is that clear for you? So judgment on admission can be passed at any stage, even without application based on oral or written admission. Okay. Sixth question. Okay. Kamal learns in 2014 that Pawan made a will excluding him. He sues in 2017 claiming I needed full proof. Court says no, you knew it in 2014. Time is up. So remember carefully. I think we are all learning about this limitation again and again. You need to fix the limitation very carefully. Plaintiff sues in November 2017 alleging a will of 2014 is fraudulent. Defendant seeks rejection of the rejection under order 7 rule 11. Okay. Time barred. Limitation starts when cause first arises. The date of knowledge is very important. So limitation period should be what? Within the 14, 15, 16. Within 3 years, you have to file the limitation. So it is not considered. Seventh question. Pawan gets NDPS charge dropped mid-trial. Kamal, the prosecution objects. Court says the true. We can modify charges, not erase from it completely. So you can modify the charges, but you cannot erase it completely. Okay. This was decided in which case? Directorate of Revenue Intelligence versus the Rajkumar Arora case. Mid-trial. NDPS charge is deleted under section 216 CRPC. Is it valid? Yes. No. Because why? Section 216 allows only admission or alteration, not deletion. So you cannot delete it. You can just alter it. Okay. You can just modify it. That's it. Now, next, eighth question. Eighth question says about what? Eighth question is very simple. It says about Kamal is added later to arbitration through no prior notice. He objects. Tribunal says you signed the agreement, you're bounded, notice or not. Okay. So first, if you make an agreement, if you say that arbitration is specifically mentioned, then you need to follow it. That's it. Okay. The tribunal can be implead parties if they are signatories to the arbitration agreement. So Advaita filed a Section 11 petition only against one party, later sought to add two more through without Section 21 notices. Object not maintainable because tribunal can implead parties if they signatories to the arbitration agreement. Ninth question. Pawan cancels his sale agreement. So I'm cancelling my sale agreement. Kamal sues for specific performance but does not contest the cancellation. Court says you can't enforce a cancellation contract without first getting it declared invalid. Very simple. So not maintainable, buyer must seek declaration challenging cancellation. So buyer sues for specific performance to the seller cancel the agreement without challenging the cancellation. Very simple. 10th question. 10th question is what? A rule lets retired chowkidar nominate relatives. No one challenges it. High Court strikes it down. Pawan argues no case is basically filed. The court says we can act suo motu to protect equality under Article 14. So I'll just tell you. Patna High Court struck down Bihar Chowkidar cadre rules. Suo motu on under Article 226. No formal challenge. Was it justified? Yes. Writ courts can suo motu strike subordinate legislation violating fundamental rights. So, for example, if there is any particular law which is introduced in the parliament, generally, which is violating the fundamental rights, even though if it is not brought before the honorable court, it can still challenge it. It can basically strike it. Why? Because the writ courts can suo motu strike subordinate legislation violating the fundamental rights. So any law which is fundamentally the law of the land, I can violate it. I can basically strike it down. Why? Because the writ petitions provides me that particular power. The Supreme Court and High Courts have that power. So this was decided in which case? Bihar Rajya Daftar Chowkidari Panchayat versus the state of Bihar case. Very simple, very important questions for your April perspective. You need to learn it. Very important for your exam. Wishing you all the best. This is Advocate Pawan signing off. Take care. Goodbye. Wish you all the best for your upcoming exams and ace it.